First, I would like to thank the Royal Ivy League University, and especially those who made up the UNESCO Housing Chair for this opportunity, and those present for my next event. As mentioned, I will talk about multifamily or buy-to-rent buildings. This expression refers to those residential buildings intended exclusively for residential rental and whose property belongs to a single owner. Therefore, they do not make up a condominium, but a single property that leases all of its units. Multifamily buildings are a business model that has experienced significant growth in Chile in recent years. In fact, if in 2014 there were 7 multifamily buildings, in 2024 there were a total of 196 with almost 47,000 units. This is mainly due to the high cost of housing, the steady increase in interest rates on mortgage loans, the massive influx of immigrants, the reduction in household size, and the growing importance of location and connectivity when choosing a place to live. Despite this exponential growth, there is no specific regulation for multifamily buildings under Chilean law. In this uncertain situation, for example, are the tenants of the Soma Inés de Suárez building. According to a report in the Clinic newspaper published on May 19, they have suffered different damages due to switch leaks, power outages, elevator failures, and equipment in poor condition, among others. This in addition to the administrative mistreatment of the complaints received. Is the first mass protest in Chile involving a multifamily building. This presentation aims to clarify the legal regime governing the relationship between the owner of a multifamily building and the tenants of its units. First, I will briefly describe the figure. Then I will identify the applicable legal norms depending on the situation. Specifically, I intend to address whether consumer law applies, and I will argue that it does. And finally, I will highlight some resulting consequences and pending challenges. Okay. Regarding the description of the figure, its characteristics are the following. First, the property is owned by a single person or entity. These owners are not a typical small-scale landlord, but usually A, institutional investors such as pension funds or insurance companies, B, housing developers who lease rather than sell the units and may sell the entire building later, and C, city halls or civil society actors involved in rental housing projects aimed at families unable to access the formal housing market. For example, the City Hall of Recoleta launched a project called Justicia Social 1 in 2020, offering 38 apartments to vulnerable families. Second, the rental includes additional services related to real estate features or amenities, such as multi-purpose room, game rooms, co-working space, gym, barbecue area, laundry, and pool. In simple terms, multifamily buildings combine rental housing with service provision. Their advertising often shows innovation, comfort, and service quality. These buildings are usually located in strategic areas well connected to public transportation and essential services. Third, multifamily buildings use a centralized management model. This allows for better maintenance of amenities, efficient service management, faster resolution of issues, and stable shared expenses. Since the building has only one owner, tenants avoid dealing with a co-ownership committee or general meetings, saving time and money. Finally, the contracts with tenants are written unilaterally by the owner and signed collectively. Therefore, they are considered edition contracts under the Chilean Consumer Protection Law. Regarding the applicable legal regime, As mentioned, it is essential to determine the applicable legal regime, especially whether consumer protection law applies. First, the urban lease law applies to these rental contracts. The lease law allows tenants to use special procedures in cases of damages, repairs of withheld security deposits. Still, this does not exclude the possibility of applying consumer law, which I will now address. These contracts are made with large corporations. These companies offer professional services and use professional management. This shifts the lease relationship into the realm of consumer relations. All the requirements for being a consumer under the consumer law are met by a multifamily tenant. On the other hand, the company that owns the building qualifies as a supplier under the same law. However, we must ask what aspects of this relationship fall under the Chilean consumer law. The consumer law states that this law does not apply to areas governed by a special law unless the special law is cited. The lease law does not regulate the additional services offered by landlords, so these are governed by the consumer law. The same applies to abusive clauses in standard contracts. Also, since there is no co-ownership in multifamily buildings, internal regulation cannot be interpreted as a co-ownership regulation. Instead, these regulations are drafted by the landlord to govern the use of common areas and amenities forming part of the rental contract. Regarding the legal consequences and challenges, since the multifamily building owner is a supplier, they must meet the professional standard required by consumer law. This raises questions about what duties this entails in each specific case. For example, what safety and hygiene standards must be met for pools or when allowing pets? What level of acoustic comfort, convenience, and connectivity is expected in co-working areas? If these services are promoted as professional and high quality, expectations will be higher than those for ordinary rental buildings. So, recognizing the application of consumer law to this relationship allows tenants to claim liability for poor quality or unsafe services, demand advertising integration, seek nullity of abusive clauses, and file collective actions. Thus, tenant protection is regulated in two different bodies of law, urban lease law and consumer law, which have different proceedings before different courts. This situation could cause problems for the purpose of duly protecting the rights of leases in some specific cases, preventing them in practice from obtaining full reparation of the damage. Also, the lease could be defenseless in the presence of abusive clauses that must be analyzed in the light of a regulation other than consumer law, since it is likely that the judge will declare himself incompetent to declare the nullity of abusive clauses. Lastly, another challenge is that the lease law does not regulate rental prices or contract terms, leading to possible asymmetries. Owners may set abusive rent or deposit amount. Chile also lacks public policies to regulate the growth of multifamily projects, which may impact housing prices and urban equity. It doesn't help that more than 80% of the regulatory plans for Santiago City Hall are outdated and more than 20 years old on average. However, the rental boom in Chile has also led to the adoption of measures, mainly the granting of rental subsidies. However, several factors have hindered the materialization of this subsidy, mainly the high price of leases and the low supply for low and middle income groups. Therefore, as of 2017, these subsidies are complemented with an incentive to supply so that private and public companies, including city halls, present projects aimed at housing rental for people benefiting from the rental subsidy. Therefore, their units have a limit on the total value of the rent. Although the impact of this measure is not so high, it is a relevant innovation in the Chilean housing policy. In conclusion, multifamily buildings in Chile pose challenges related to the protection that the law must provide to these new consumers, but also to the adoption of measures related to price control, the impact on spatial and social morphology of the places, and the incentive to the supply and demand of rental housing. Thank you very much.